Hi friends, today we are discussing on fire insurance, the definitions, nature and scope of fire insurance. As you know, fire insurance is taken on property. According to Halsbury, it is a contract of insurance by which the insurer agrees for consideration to indemnify the assured up to a certain extent and subject to certain terms and conditions against loss or damage by fire, which may happen to the property of the assured during a specified period. So, this is a definition given in Halsbury. Then this particular fire insurance is a personal contract, even though the fire insurance contract is classified under property insurance, a fire insurance contract is considered as a personal contract. It is not an insurance against accidents, but an agreement to protect against damage by a fire accident. Not only property can be insured, but any consequential loss also may be covered by the fire insurance policy. Any loss which is excluded from the scope of an ordinary fire policy as being too remote may be specifically insured against. So, this is a personal contract, and let us look into the what is the meaning of fire. A contract of fire insurance being to indemnify the assured against loss by fire does not extend to any loss caused by any causes other than fire. Unless there is a contrary intention, the word fire is given its plain popular meaning. To constitute fire, there must be ignition or combustion. It does not extend to chemical actions which do not result in actual ignition, though they correspond in their effects to fire. In one of the famous cases, Upjohn versus Ford, it was held that damage caused to sugar by the heat of furnaces does not fall under the fire insurance policy. Looking into the fire or explosions, two kinds of explosions. First one, explosions caused by an explosive substance, for example, gunpowder or gas coming into contact with fire. Second type of explosion is explosions caused by the application of fire to a substance not of itself explosive, for example, boiler. In one case, that is Everest versus London Assurance Company, the plaintiff effected a policy of fire insurance on buildings. A quantity of gunpowder belonging to a gunpowder factory of a third person a half a mile distance away from the insured property ignited and exploded, and consequently the windows and window frames were shattered and the structure was damaged, generally by the atmospheric pressure caused by that explosion. It went to the court, and Justice Biles held that the insurance company was not liable because the loss was not caused by fire within the meaning of the policy. The house itself was not burned, but was damaged due to concussion of the atmosphere. It has therefore become a general practice amongst the insurers to deal specifically in their contracts with losses by explosion so as to express with precision the extent of their liability. So, explosions of boilers, if in the course of fire a boiler is caused to burst, the loss of the boiler is the loss by fire. Any other loss occasioned by the explosion at any rate in the premises in which the fire is seems equally to be covered under policy. Then what the loss, what is loss by fire, what it covers? Let us look into that point. In order to constitute loss covered by a fire policy, there must be an actual fire or ignition. Any loss attributed to the fire, whether by actual burning or by cracking or scorching or by smoke or otherwise, will have to be borne by the insurers. If the assured has deliberately set fire to his own property, his loss nonetheless is won by fire, although public policy will prevent him from recovering under the policy. So, here deliberate act of the policyholder on his own property, if loss occurs, for that insurance company is not held liable. A fire caused by negligence of the assured is covered under the policy, and incendiarism, that is mischief of fire, is usually covered by fire policies, but any threat of incendiarism must be reported to the insurers immediately. Further, any loss resulting from bona fide efforts to put down fire is within the policy. It sometimes happens that property may be damaged or destroyed or is sustained as a direct consequences of fire, though the property is not directly burned by fire. So, let us now look into the circumstances such loss is directly attributable to a fire may be regarded as covered by the fire policy. Let us look into those things. First one, damage by smoke and scorching caused by fire within the meaning of the policy. Second one, property blown up to prevent the fire from spreading is covered under policy. Property damaged by the water used for extinguishing the fire is covered. Damage done by fire brigade in execution of its duties is covered. Loss to property removed from burning building caused by rain, theft or damage during removal, provided that removal was justified and was made in an honest attempt to mitigate the loss. Then loss occasioned by the fall of walls or part of a building in which the fire take place. So, under all these circumstances, yes, fire insurance policy is covered and the insurance company is held liable for the loss. Then what is this consequential loss and how much it covered under the policy? Let us look into that. This type of insurance is intended to supplement the protection given by an ordinary fire policy. There cannot be separate consequential loss policy without an ordinary fire policy. The claim under this head can succeed only if the insurers adjust their liability for loss of property by fire under an ordinary policy. It generally provides indemnity for following kinds of consequential loss, namely loss of profits, standing charges, increased cost of working, increased cost of reinstatement. So, even these are also covered under consequential loss under the fire insurance policy. See, when a person wants a fire insurance policy and approaches the insurance company, immediately they issue cover note. They may not sometimes give you the policy, they give cover note. In practice, on making the proposal, the insurance company on payment of the premium gives a deposit receipt called cover note. It is also an interim protection note. You may call it as an interim protection note until final policy is issued. In one of the case, Ratialal versus National Security Assurance Company, the Supreme Court observed that a letter of cover or cover note is not defined in the Insurance Act or the Stamp Act. It may be shortly stated that the letter of cover no doubt contains a contract of insurance, but it is not a policy of insurance. It is only a protection for the interim period between the date of proposal and the date of issue of the policy, and therefore, the cover note is a protection for the interim period. Sometimes the cover note may mention the period, maybe 30 days, so like that. So, in such cases it covers only for that period. So, within that particular period, insurance company issues the policy, final policy to the policyholder. Let us look into the how fire insurance policies are classified. We can classify fire insurance policies into three categories: long term policies, annual policies and short term policies. So, let us look into one by one in detail. Long term policy, the usual period of cover in fire policies for 1 year, and it is for a longer time than that, like a policy for a term of 2 or more years, it is called a long term policy. In such cases, the whole of the premium is payable at the inception of the contract. This must not be confused with insurances with long term agreements where the insurance is for 1 year, but the insurer agrees to renew the insurance contract annually at a premium subject to discount for a long term, say 3 years or 5 years. Always fire insurance policy is given for maximum 1 year. Every year it has to be renewed, and they can take lesser than 1 year also. So, the annual policy, the second one, it is for the 1 year. So, at the time of entering into the contract, they have to pay full premium, and they have to take a policy for 1 year. And last one, short term policies, it is lesser than 1 year, even maybe 1 month, 2 months, 5 months. So, depending on the insurable interest of the party or the owner, he can take for the short term. So, that is also allowed. Then in case of fire insurance, who has to prove? That is burden of proof. Burden of proof is on whom? Is it on insurer or insured? So, let us look into burden of proof in fire insurance. In case where fire is alleged to be intentional, the burden of proof is on the insurer. Once the insured has shown that loss was due to fire, he has made out a prima facie case, and then the burden of proof shifts to the insurer to prove that the claim is incorrect as the fire is intentional. So, that is, in case of once the policyholder proves that there is a fire and there is a loss, then if insurance company tries to deny the claim, then the burden on them to prove those exceptional clauses. In one of the case, Shobika Athier Majors versus New India Assurance Company 2006 Supreme Court judgment, the complaint for compensation against insurance company under fire insurance. Showroom of textile garments looted by armed rioters consequent upon series of bomb blasts and showrooms also set to fire. Claim for damage for entire stock stored in showroom which comprised of 2 basements levels as also the ground floor level. Insurance company assessing the damages excluding stocks in the 2 levels of the basements. They accepted the ground floor loss, but they denied the 2 basement levels stock loss. Supreme Court held that nothing on record to indicate that stock in trade had been removed from basement levels in anticipation of rioting. Owner of showroom having discharged initial burden regarding destruction, damage of showroom and stock therein by fire and riot. Rejection of claim in respect of stock in 2 levels of basement not sustainable, and ultimately Supreme Court said insurance company is held liable because the insurance company failed to prove what it wants to say. Let us look into the insurable interest in fire insurance. A person who is so interested in a property as to have a benefit from its existence and prejudice by its destruction is said to have insurable interest in that property. Such a person can insure the property against fire. The interest in the property must exist both at the inception as well as at the time of loss. If it does not exist at the commencement of the contract, it cannot be the subject matter of the insurance. And if it does not exist at the time of loss, he suffers no loss and needs no indemnity. Thus, where he sells the insured property, and it is damaged by fire thereafter, he suffers no loss. So, insurable interest is a very important concept in insurance law. Without insurable interest, nobody can take insurance policy on the property. He should be a owner or he should get the insurable interest through contract. So, let us look into how third party is not a owner, even then third party gets the right to take fire insurance policy on the property. So, first one, in case of mortgage. In case of mortgage, mortgager and mortgagee have both distinct interest in the mortgage property and they can insure. And then in trustees, trustees are legal owners and beneficiaries, the beneficial owners of trust property, and each can insure it. And then is bailees. In case of bailment, bailees such as carriers, warehousemen are responsible for their safety of the property entrusted to them, so they can also insure it. So, here as a owner, yes, owner can take a fire insurance policy, owner of the property can take fire insurance policy. If he is not a owner, then other person through contract he gets the insurable interest, then that person can also take fire insurance policy on the property, as I have said, maybe in mortgage, mortgagee, lessee, trustee, bailee, like that. These are the persons who are not owners, even then they get the insurable interest through contract and they can also take fire insurance policy. So, this is about the introduction about fire insurance. Thank you.